This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about the unintended auto exclusion in the jeweler's block policy. First, you must understand a jeweler's block policy is a very strict inland marine coverage that insures against serious risks of loss because the items carried by jewelers are fungible and easily sold. A package of diamonds that would fit into a small envelope in a jeweler's pocket could be worth as much as $2 million. So the insurer is reluctant to take the risk without protection. They always include an exclusion for losses from an unattended auto. And these are created to curb what is called a moral hazard and to limit coverage in the high-risk settings even where there is no moral hazard. Now, moral hazard refers to the effect of insurance in causing the insured to relax the care he takes to safeguard his property because the loss will be borne in whole or in part by the insurance company. Even if there were no moral hazards, an insurer might want to exclude coverage in especially risky situations. More precisely, the insured might agree to accept less coverage in exchange for a reduced premium. Jewelers and their counsel must be aware that the jeweler's block policy, although it still insures against all risks of physical loss, insurers will not take certain specified risks. Because of the risk attendant upon high-value property, the jeweler's block policy contains a strict exclusion concerning theft losses from vehicles. For example, a jeweler traveling with a case full of diamonds stops at a self-service gas station to fill his car with gasoline. He locks his car, leaves his case in the car, and walks 50 feet to the attendant to hand in his credit card. As he turns to return to his car, he sees a thief break the window of his car, snatch the case, and run away. The jeweler confidently reports the theft to his jeweler's block insurer and is shocked to learn the loss is not insured. The clause comes in various guises, including, quote, unattended auto. We do not cover theft of property in or on a vehicle that is not attended. An attended vehicle has a person actually in or on the vehicle. This person must be you, your employee, or a person whose sole duty is to attend the vehicle. This was from a Jeweler's Mutual Insurance Company jeweler's block policy. Or consider this policy does not insure loss of or damage to property while in or upon any automobile, motorcycle, or other vehicle, unless at the time the loss or damage occurs, there is actually in or upon such vehicle the assured, or a permanent employee of the assured, or a person whose sole duty it is to attend the vehicle. This is from the Lloyd's OL Form NMA 2612, 9395, the Lloyd's Underwriters Non-Marine Association's Jeweler's Block Policy. The case law on the subject is not extensive. The case law that exists, however, almost universally supports the exclusion and adopts the position taken by the insurers that the exclusion in a theft policy from loss from an unattended and unlocked vehicle is proper has been recognized in insurance policies and insurance law since before the invention of the automobile. However, in EMMI Inc. versus Zurich American Insurance Company, a 2004 decision, the California Supreme Court, apparently rejecting its own well-established rules of construction of insurance policies, rewrote the wording of a jeweler's block policy in what appeared to me to be a case of reasoning backward to provide insurance coverage for a jewelry salesman who was exceedingly stupid. He left his jewelry in his car with the keys in the ignition and the engine running to check on a clanking noise, only to have a thief jump in the car and drive away with the jewelry. The Supreme Court has compelled insurers to make their coverage even more restrictive. The Supreme Court majority, finding an ambiguity in the word upon, has redefined an exclusion requiring an insured to be in, on, or upon the automobile at the time of loss for coverage to apply to mean in close proximity. As Justice Kennard stated in her dissent, quote, "The majority's holding misreads the plain meaning of the language and is contrary to the holdings of the overwhelming majority of courts in other jurisdictions. We should enforce the contract between the parties as it is written, not rewrite its terms." Close quote. The majority of the California Supreme Court disagreed. So until the policy wording changes to comport with the holding of the California Supreme Court, stupid, lazy, or incompetent jewelers who for more than 100 years knew there was no coverage for a theft unless they were in, on, or upon the vehicle, now can get coverage if they walk away, as long as they don't walk too far away. The close proximity definition chosen by the California Supreme Court is so loose and ambiguous that it may result in hundreds of lawsuits to determine if 2, 4, 10, or 20 feet from a vehicle is close proximity. Intelligent insurers will modify the language to provide less coverage and to avoid arguments of ambiguity by merely eliminating the words on or upon and require the insured to be actually in the automobile at the time of the theft for the loss to be covered. The provision at issue exempted jewelry stolen from a vehicle from coverage unless the insured was actually in or upon such vehicle at the time of theft. The question presented to the Supreme Court was whether the exception to that exclusion applies when the insured is not in the vehicle but is in close proximity to the vehicle and is attending to it when the theft occurs. The Supreme Court concluded the vehicle theft exclusion as a whole is ambiguous and fails to plainly and clearly alert insureds that there's no coverage if a theft occurs when the insured has stepped out of the vehicle but remains in close proximity and is attending to it. In this case, Brian Callahan, a jewelry salesman, left his home with 2 hard cloth garment bags containing jewelry, some of which belonged to EMMI Inc., a manufacturer and marketer of jewelry, in the trunk of his vehicle. Shortly after driving away from his home, he heard a clanking noise emanating from the rear of the vehicle. Callahan stopped on the side of the road to investigate the source of the noise, got out of the car and closed the car door, but left the engine running. He walked to the rear of the vehicle, and as he crouched down to visually inspect the exhaust pipes, he felt someone pass quickly by him. When he looked up, he saw an individual get into his car and drive away. Callahan was more than approximately 2 feet from the car during the entire time he was outside the vehicle until the time of the theft. The police subsequently found the vehicle, but of course the jewelry was missing. In this case, 2 feet from the car, where he was too far away to stop the thief from entering his car and driving it off, is close proximity, and therefore to the California Supreme Court not excluded. Jeweler's block insurance was conceived at the turn of the 20th century. It provides coverage under a single policy for the various risks inherent in the jewelry business. In the present case, EMMI, the policy excluded from coverage theft from a vehicle unless the insured or designated employee was actually in or upon the vehicle at the time of the theft. As the Minnesota Supreme Court has observed, the exclusion was obviously intended to cover any situation where a loss occurred when the property was not protected by someone in or upon the car. In Minnesota, the Supreme Court, in a case called Ruvelson v. St. Paul Fire and Marine, in 1951, upheld the exclusion and concluded, the doctrine of substantial compliance has no application to the facts of this case, where the words used in a contract of insurance expressly require actual compliance. It is difficult to conceive of a more effective deterrent to a potential theft than the presence of someone in or upon the automobile. Close quote. New York courts held there was no coverage in Royce Furs versus Home Insurance, a similar policy, a furrier's block instead of a jeweler's block, and concluded coverage did not apply even when the car was left unattended for only 5 minutes and the entire vehicle was under surveillance through a window of the hotel. In Hanover Insurance Company versus AMI Diamonds, a 2005 decision of the Seventh Circuit, it upheld the exclusion for the following reasons: to curb what is called moral hazard and to limit coverage in high-risk settings, even when there is no moral hazard. The Seventh Circuit, criticizing the Supreme Court, held EMMI is an outlier. To read upon to mean near would open a large loophole of uncertain limits, something the cases we've cited and others as well are clear and have refused to do. If in or upon is given the same meaning in both places and upon means near, then the exclusion is inapplicable if the diamonds are merely near the vehicle and not in it, which would be preposterous. Close quote. Most cases interpreting similar policy language have found the phrase in or upon the vehicle to be unambiguous. See, for instance, the annotation, construction, and effect of jeweler's block policies or provisions contained therein at 22 ALR 5th 579 or Couch on Insurance 3rd edition. Based on exclusions with nearly identical language, courts have consistently denied coverage to insureds who were not literally in or upon their vehicles at the time of the losses, even though the insureds may have been only a short distance away from the vehicle, watching the vehicle, or absent from the vehicle for only a short period of time. No insurance policy insures against every loss, however. In the case of Equity Diamond Brokers versus Transnational, a 2003 decision from the Ohio Courts of Appeal. The insured specifically assumed the risk by declining unattended vehicle coverage which had been offered to him. In addition, the United States District Court for the East District of New York held in Selig v. St. Paul in 1953 decision that the purpose of the policy with regard to this exclusion was to cover a loss only if it occurred in connection with the holdup of a motor vehicle while being operated by a permanent employee of the insured. The court concluded there was no coverage, although the employee was only a short distance from the vehicle at the time the theft occurred. It therefore appears to be the consensus of those courts that have considered the issue, except the California Supreme Court, that unattended automobile exclusions, like those quoted above, are clear, unambiguous, and enforceable. This video was adapted from my book, Zalma on Insurance Claims, Part 104, Second Edition, and is available as both a Kindle book and as a paperback from Amazon.com. If you found this video to be of use to you or of interest, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel and my Rumble channel and to my blog so that you can be advised of future blog postings and videos. Thank you for your attention.